just a second.
All right.
Okay, let me just back up a slide.
There we go.
Okay, hold on a second. Okay, whoops. I can tell you guys right now, it's always user error with me when it comes to technology. It's a challenge. When it works, it works. When it doesn't, it doesn't. Okay. New share. Okay. All right. I think we're set. Can you guys see the screen? Okay.
Yes.
Okay, wonderful. All right. So basically, what we have here is what I've done is I've actually pulled some excerpts because I think as I was saying to Tom, I think it's real important that we understand, where it is in writing instead of us just telling you guys, oh, this is the legal obligation and blah, blah, blah. I want to show you all the places where it's in writing in our contracts, from the listing agreement, as well as the purchase and sale agreement, as well as the brochures, and then also show you some law around our duty to disclose, which would be in Beretta. So what I hear, and I know Tom can back me on this, what we hear a lot of times is when I'm teaching contracts and we discuss the duty to disclose and things like that, I hear this constantly. I hear, oh, but the seller never lived there. Oh, but it's sold as is. Oh, but it's an investment property. None of that matters. Absolutely does not matter at all whatsoever. Any known defects have to be disclosed by the seller, and any known defects have to be disclosed by you as the agent if the seller will not disclose. So first up, I have where the seller has actually promised and in writing to disclose in the GAR listing agreement, also known as the seller brokerage agreement. The seller has agreed, this is the paragraph from the seller's property disclosure statement, paragraph, I should say, in the actual listing agreement. And it actually, I like this paragraph because it cites the statute, the Georgia statute, which is Title 51-6-2. Not to mention, in addition to this, the countless amount of case law out there to support the fact that a seller has to disclose any known defects. So it says they have to disclose any known latent defects. Latent just means not visible to the naked eye, hidden, etc. That has to do with the property. And then we, under Beretta, we as agents, if we know of any hidden defects, which I'll be showing this to you in a little bit, have to disclose anything within a mile radius of the property that's a defect that can't be detected with a normal visual inspection. So I'll give you some examples when we get to that section. But anyway, so this is a statutory requirement.
This is what she's stating here, and what this Georgia law, it's a state law. I want everybody to understand that.
And the seller's already promised to do it. So when you have a situation where a seller's like, oh, I don't have to do that. And guys, I will tell you this in class all the time. Rule number one is don't take advice from other agents. And what I mean by that is don't just engage in bad practices because other agents are doing it, because that is absolutely all day long going to be violating rule number one. And when I hear agents again and again and again saying stuff like, oh, well, the seller never lived there, or it's as is, so we don't have to disclose, and blah, blah, blah. That is simply agents out there seeing what other agents are saying and doing and engaging in bad practices. So their seller in their listing agreement has already agreed to disclose any known defects. The fact that it's sold as is, because our GAR purchase and sale is an as is contract. The fact that it's sold as is irrelevant. The fact that they've never lived there is irrelevant. The fact that it's an investment property, irrelevant. If you know of a defect, you have to disclose it. Seller doesn't have to repair it, but they do have to disclose it. And if the seller won't, and the agent knows of the defect, they have to disclose it in writing. So right here is, again, where the seller's made this promise in the listing agreement, and they've agreed to use one of the GAR forms, the F301, the F304, the F307, or the and those are probably the specialized forms for like land disclosure, condominium disclosure, things like that, because we have specialized for different types of property, or at minimum the F302, which is the disclosure of latent defects. And then it says that the seller agrees to promptly update any of the above disclosure documents through the closing should any changes occur. So here's the deal. As sellers are receiving information about defects, and that is most commonly going to come in the form of inspection reports, as they are receiving knowledge of defects, they have to update their seller's disclosure statement. And if they won't update it, you have to disclose those defects that are discovered along the way through inspection reports that are sent to you. So let's move to the next slide, because this
Okay,
just,
can I just interject one thing
yes,
here, guys?
of course.
So there's a lot of if I list a house and I know there's going to be a lot of issues with the inspection, I always ask the agent just to send me the pages that accompany the items that they're asking for. I don't want to see that whole report, because many times, you know, you'll have a home inspected and they don't ask for certain things. They just go, they ask for some things and they don't ask for everything. If you've got that report and your seller has that report and you all look through that entire report, guess what? You've got to disclose it. So anyway, just want to make that point clear. When agents randomly send you an inspection report, sometimes that may not be a good idea.
Well, but and we're going to talk about, once it's been delivered, you can't put the genie back
Once
in
it's
the bottle.
delivered, it's delivered.
And once it's delivered, you're responsible for all the content, even if you don't open it, and you're also responsible for delivering it to the seller. And even if they don't open it, every bit of the nitty-gritty details, you're responsible. Mika, if you want to unmute
Mika.
yourself.
Thank you. That was going to be my question, because I was in Angie's class last week when she talked about, if the inspection report comes to you, now it's your information. So there's no way to unsee it, or once it hits your inbox, now
That's right.
you're on for it, right?
And I'm going to show you the language that says that. And this language has been tightened up in the past year or so in the GAR forms. So let's look at the next slide. Disclosure of defects, again, that's the title. It's not optional. This is an excerpt from the GAR brochure. I highly recommend that you guys are giving these GAR brochures, because they are legal advice straight from our GAR attorneys. And this GAR brochure is the CB10, and it is understanding your disclosure obligations. And this is where it's educating the seller. And we have obviously brochures for buyers as well. These brochures are ultimate layers of protection for you as agents, as realtors. I cannot stress that enough, because it's giving actual legal advice and recommendations to the buyers and sellers. So this is actually the paragraph that deals with the seller's obligation to disclose lead-based paint, their lead-based paint exhibit, and the pamphlet obligations, as well as defects, regardless of whether the house is sold in as-is condition. And it's explaining to them that this is a statutory and also a case law requirement. Nick, you had a question?
I did. Thank you. Real quick. So on both slides, it mentions something regarding the property not being readily available for an inspection, but that wasn't highlighted. So it says sellers have a duty to disclose latent or hidden defects in their properties that are not readily apparent for a reasonable inspection of the property. And the slide before that had something that referenced the same thing. So what if it is readily available for an inspection? Is that still a requirement? Because
Yeah.
it doesn't.
Well, it's not so much inspection. The way I like to look at that, the way I would interpret it is if it's obvious and the ceiling is caving in, you know, or there's an obvious hole in the roof and water is coming in, that particular defect, you arguably don't have to disclose the obvious, but invariably there's more damage that is probably there that's not obvious. The hole's obvious, but there could be rotten rafters, there could be more damage inside the roof mechanism that people don't see. So that's why you hear people say things like, when in doubt, disclose. What it's referring to is if you can see it with your naked eye by observing as a buyer walking through the property and you can see there's a huge hole in the floor, then obviously that's not a latent defect, that's an obvious defect. What you might not be able to see though, and what the seller would probably have knowledge of, is the hole in the floor is there for a reason. There's rotten rafters underneath. And the rot's not isolated to this one hole. There's rot, there's structural damage, there's things that a person can't see, and that would definitely have to be disclosed. So when in doubt, disclose. And the lack of disclosure is the number one reason that a seller is likely to be sued and sued successfully. And the lack of disclosure of defects is the number one reason why a broker and their agent are going to be sued and sued successfully. So disclosure is what you're doing, is taking the burden off the seller and off the agent. When you disclose defects, you know, you are taking the burden and putting it squarely on the buyer and saying, there's no obligation for us to fix these defects. We just have to disclose these defects and take it or leave it. And it puts the burden on you, the buyer, to then you're making an informed decision. We've disclosed it. Now you've made an informed decision, and you can't come back on us later saying we were deceptive to you. Does that make sense, Nick?
Yeah, it does. But I know you mentioned even if it said, I saw it read, even if it says as is.
Correct.
Right. So
those are completely different issues. If you're going to sell me something as is, you got to tell me what as is.
Okay, understood.
Okay, let's check out the next slide. So this is an excerpt because, again, I like to pull all the language for you guys so that you're more savvy on understanding where all this is in writing when you have people arguing with you. Maybe it's the other agent, maybe it's your client arguing with you that they don't have to do this and they don't have to do that. And nobody agreed to this and nobody agreed to that. I'm going to tell you that's not true. It's in multiple places. This is from page 4 of the purchase and sale agreement, your inspection and due diligence paragraph, and it's subparagraph G. So paragraph 8 is your inspection and due diligence, which, as you guys know, are two different things. Inspection rights are alive from the time of binding agreement, and due diligence is a right to terminate for any reason. And obviously, when you have a powerful right like the right to terminate for any reason, you would want to determine whether or not to exercise that right. And it would make sense that if the product was not in good shape, that you would want to exercise that right. Hence, all the more reason to do your inspection, obviously, during due diligence. So or any inspections that you can think of to determine whether you want to proceed. Morgan, you have a question?
Yes, thank you. So I was thinking, what happens if the seller wants to describe the property as an as-is property in the FMLS system, but does not want to fill out a disclosure because they never lived in the property, even the disclosure saying that they never lived in the property? That protecting me? Go ahead.
No, what I'm trying to educate you guys is there is no such thing as is and no disclosure going together. That is something that started as a very bad practice during the recession years when we had a huge amount of foreclosure properties hit the market, and you would have agents put in the MLS as is no disclosure, as if those two were married and went together. And they would do that because they would perhaps have a foreclosed property that was a Fannie Mae owned property or Bank of America or something where the entity was owning the property by default. They had no knowledge. They had never even seen the property, the entity. And so there were certain limited exemptions for that entity, Bank of America, Fannie Mae, Freddie Mac, whatever, based on the fact that they had never even seen the entity and they owned the property simply by default because somebody failed to pay their mortgage. However, even those entities with all their 16-page addendum packages that says, I don't know, and I can't disclose things that I don't know. Well, guess what, guys? Nobody can disclose things they don't know. But once you know things, and I don't care if you live there, it's irrelevant, you inspected it, you maintained it, any work done on it, you did, any improvements on it, you did. You know, and the number one thing you could do as a seller is to disclose, because you are then putting the burden on the buyer to say you're making an informed decision. And at minimum, we want them to fill out the short form, which is the disclosure of latent defects. They have more knowledge than they think they do. They inspected it in some form or fashion before they bought it. They probably did some repairs and rehabbed it, which means that they most likely discovered some stuff. Living there has nothing to do with it. And I actually saw cases where even though Fannie Mae was the owner and they had all their no disclosure addendum package, because along the way they discovered things through inspection reports, now all that was blown up. Their no disclosure is blown up because as soon as they get sent the inspection reports, they now have knowledge of defects, even if they are Fannie Mae or Bank of America. Right. And I saw Freddie Mac strike a check for $12,000 to a buyer that bought the as-is property with no disclosure because it was detected that it had a major rat infestation, and that later when the buyer's attorney sent a demand letter, they investigated and realized that one of their workers, in preparation to get the property on the market, had checked a little box on the report that was sent to the asset manager that said evidence of rodent infestation, and that was never disclosed to the buyer. So that little mark by their own subcontractor that was there to get the property ready was sent to their representative, the asset management company. Nobody paid any attention to it, and nobody subsequently did anything about it. And that was a defect that never got disclosed. And so Freddie Mac, without going into any legal whatever, they struck a check and paid that bill and paid for that rodent infestation to be remedied, because it was obvious somewhere along the way they had been that they had been given knowledge of a defect. Does that make sense?
Absolutely. Thank you so much.
Of course. Okay, here's your notice paragraph. I'm preaching this and I will not stop preaching this. This is basically saying that it's in the purchase and sale agreement. This is where notice is defined. And it says that basically all notices have to be in writing. And if it's a notice that requires a signature, such as a binding contract or an amendment or an actual written notice, then it has to be signed by the party, and the party is the buyer or the seller, not you. You can be the delivery person of a notice, but you're the delivery person. But a notice such as you sending an email or a text message to a fellow agent is not ever going to be considered quote unquote legal notice. It's you're the delivery person of a notice that's signed. The
Can
same.
I interject, Angie?
Huh?
I need to interject this, please.
Sure.
And guys, you know, this is really, really important. And you've heard us talk a lot about the notice form, which I feel is very underused in transactions.
Yeah.
We're so used to emails and texts going back and forth between the agents. And at the end of the day, none of that is notice. And so we really need to get into the habit now of using this notice form and having your sellers or buyers sign those forms and put that in your file. If we get an investigation, which I can tell you that we do, then we will have that as proof of notice from the parties, not from the agents. I get screenshots all the time of texts between agents, and guess what? Doesn't mean anything.
That's right.
Please be very cognizant of that, and let's make it a habit to use the notice form and have your buyer and seller sign it.
Absolutely. Thank you, Tom. It's so important because a lot of times you have especially sellers that are required to send notice to buyers. Like, for example, if a seller's trying to notify a buyer that they are now the primary contract and you have a backup contingency exhibit and it requires the seller notify buyer that the previous primary contract has now terminated and that the backup buyer is now in primary position, that requires a notice signed by the seller. We have a generic multi-purpose notice form that can be signed by either a buyer or seller, whoever's giving notice, and that is the GAR F816. And so that is your form. Let's say you're representing a seller and you have a kickout provision and you have somebody who has the seller lease contingency exhibit attached and there's a kickout provision and you want to notify the buyer that the seller's exercising their kickout provision. You have to use the actual notice form to do that. It has to be signed by the seller and state that the seller's exercising the kickout provision. And otherwise, you sending an email is no notice has actually occurred. In the no financing contingency exhibit, if the buyer does not deliver the proof of funds of their proof of funds requirement within a certain number of days, seller can't just terminate. They have to send them a notice and give them 3 days to cure that problem by delivering the proof of funds. And then and only then, if they refuse and do not send the proof of funds, then the seller could terminate. But that requirement is actually in that no financing contingency exhibit. And it says seller's right to terminate, and it gives you these instructions, and it says they have to send a notice giving them 3 days to cure. An email from you is not going to suffice. You've got to use the F816 notice form and have your seller sign it, and then send them the notice stating what needs to be said. Yes, Morgan?
All right, one more question. Sorry about that. So let's say that your seller is basically saying they don't want to disclose something that you know that they have fixed.
It's a defect.
A defect, right? So let's say this. Can't we as realtors just submit the notice form on our behalf versus the seller's behalf?
No, because it's that particular form is only for a party to sign. What you would do, and I believe that there is a GAR form for it. There's a broker disclosure form. There's a broker disclosure form in the GAR forms you can fill out. You can actually also send people copies of the actual inspection reports. And I've actually had agents do that. I had an agent that had, back in the recession years, I had an agent that had lots of, that was her primary thing. She did the Fannie Mae, Freddie Mac, and HUD listings. And so all of those entities, they used to, drill into everybody's head, oh, we don't provide a disclosure because we have no knowledge. And I'm like, yeah, that's great until you have knowledge. And when do you have knowledge? As soon as your agent has knowledge. And as soon as a report is sent to you. When you have a report sent to you, whether you asked for it or not, it's what you can't unring that bell. And so that report gave you knowledge, and now you have to disclose that. You don't have to fix it, but you do have to disclose it. So in that case, there is a broker disclosure form that you can fill out in the GAR forms disclosing the defect. And also there is just giving them the actual report. By the same token, if you ever have contrary reports, and one of the Weissman attorneys told me this, and they are not only the attorneys for the Georgia Association of Realtors, they're the biggest real estate litigators that deal with real estate litigation in the state of Georgia. So they know about all these liability issues. And they reiterated to me that if you get maybe 2 or 3 different reports that say this is, the radon level is okay, the radon level's not okay, the mold level's okay, the mold level's not okay. you are obligated as the agent, even if the seller doesn't want to, you have to go ahead and deliver all those reports and let the buyer make that informed decision in order to put them on notice that we have contrary reports, and we're not going to be the deciding factor as to what's accurate or true, or we're not going to cherry pick the one that favors us best. Because I guarantee you, if you get into a lawsuit where you have an undisclosed defect, it can escalate up to hundreds of thousands of dollars. And the attorney that is hired, a litigating attorney, will absolutely eat your lunch. And no excuse you come up with is going to matter. And we're going to look at Beretta, which is our statutory requirement to disclose. But let's finish this notice paragraph. See here in section B where it says delivery of notice, I highlighted even if it is not opened by recipient. So once it's delivered to you, it's delivered to you. And even if you don't open it, you now know about it. And you're responsible for the content in that document, even if you don't open it. You'll have agents out there trying to tell you, oh, I didn't open it and my seller didn't open it. The GAR Forms Committee has gotten tired of that because they know that's never going to hold water in a court of law, in a lawsuit. So they added this language here on purpose to try to educate agents that will not fly. Go down here under paragraph C, it says broker representing a party in a client relationship shall be authorized agents of the party for the limited purpose of receiving notice. You're the delivery person back and forth. If you receive something, you must deliver it to the client. And it says, and such notice of any, and such notice to any of them shall, for all purposes herein, be deemed notice to the party. What that means in simple terms is when you receive it, legally, your client has received it. You are a funnel, not a filter. You have to actually deliver that which is delivered for that client. You cannot, even if the client tells you, Morgan, I don't want you to forward me that inspection report. Legally, once you have it, Morgan, that client legally has it. Okay. And you do not have the right to filter it, even if the client is telling you, please don't send it to me. You don't have that right. And legally, this language says they legally have it because you have it.
Sounds good. Thank you.
Okay. Wonderful. Let's look at Beretta.
Angie,
Yes.
Angie, I got a question real quick
Lamar.
before you go into that. So when is it, if at all, is it a good idea to have your seller do a pre-listing inspection?
I was a big fan of pre-listing inspections. I did one on my own house a couple of houses ago, and I wanted to know what was going on and remedy any defects because I knew my house was well maintained. So, a lot of times I think it's a good thing if you have a seller that feels like their house is, obviously well maintained, and they want to go ahead and be preemptive and attack, the problems and overcome problems. And in that case, the house sold quickly, and the inspection issues were so minor, they were almost inconsequential, like super duper minor, and no big deal. And so I did that to help with my marketing and to help just, make it easy when it came down to the inspection. And, with my other house that I sold last year, not only did I do that, but there were some key components in the house. We just went ahead and replaced things. And again, the buyer, it sold for the highest dollar ever in the neighborhood. And the buyer was like, this is a no-brainer. And and we even shared a previous inspection report with them that we had received from the first buyer because they terminated because it was too far of a drive. And we shared that inspection report. And the second buyer's like, good, I'm paying you an extra $40,000 and I don't need to do my own inspection. But they knew it had a new roof. It had a new hot water heater. It had both HVACs have been replaced in the past few years. So it can be a good marketing tool. And, it just depends. But the bottom line is they can't, if you'll have the sellers argue, I don't want to disclose because I think that's going to hurt me. and hurt my chances. What hurts you worse, seller, is not disclosing, because then you are damaging the public. And if you're damaging the public, that could get you sued big time, like sued like you can't even imagine. These things can escalate into the hundreds of thousands of dollars. It's really bad. And so I just can't stress that enough. When you disclose, you take the burden off the seller and off yourself, because you put the burden onto the buyer. You are now able, now that you know what as is, to the best of my knowledge, and now you can make an informed decision. Did you have another question, Morgan?
No, I can unraise my hand. Lower my hand. Sorry about that.
Okay, no problem. Okay, let's look at Beretta. Now, Beretta, a lot of people think that Beretta, Broker Relationship and Real Estate Transaction Act, we hear it, but we don't all necessarily think about it or even know what exactly it means. Beretta is not enforced by the Real Estate Commission. Beretta is actually enforced through litigation. It's the statute that brokers get sued for. And when I say brokers, I don't mean Tom, I mean all of us, because Tom might hold our licenses, but when you're a finger attached to the body, and if that body's going to get sued because of something you did or didn't do, you're going to be named in that lawsuit as well, sometimes even named individually. So you have to be very aware of, you know, having the responsibility of being that finger attached to the body. And in Beretta, it says, and this is a statute, and you can link to this by going to the Real Estate Commission website, and you can click on license law, and down below where you have the Georgia Real Estate Commission rules and the license law, you'll see a link to Title 10, which is Beretta, and it'll take you to a website. And you can actually pull up paragraph 6A under the in the LexisNexis list of Georgia statutes. But it says here that a broker engaged by seller shall timely disclose the following to all parties with whom the broker is working. Number one, all adverse material facts pertaining to the physical condition of the property and improvements located on such property, including but not limited to material defects in the property, environmental contamination, and facts required by statute or regulation to be disclosed, which are actually known by broker, meaning you as the agent, which could not be discovered by reasonably diligent inspection of the property by buyer, and material facts pertaining to existing adverse physical conditions in immediate neighborhood within a 1 mile of the property, which are actually known to broker and which could not be discovered by buyer upon diligent inspection of the neighborhood through a review of reasonably available government regulations, etc., maps, records, statistics. So, for example, it's not just about the property, it's also about the neighborhood and that whole mile radius of the property. A lot of you have heard that, but you don't necessarily know where that language and that requirement comes from. It comes from here, from Beretta. If there is a landfill within a mile radius of the property, I would disclose it, just not because legally I'm not required to. You know why? It's not hidden. That's not hidden. Landfills are massive. They're huge. So it's not hidden. That's something you would not have to necessarily disclose. What you would have to disclose is if there is a drainage issue in the neighborhood. Maybe it's on the other street. Maybe it's around the corner, but it's a drainage issue and it causes flooding. Maybe there's a situation where the neighborhood all knows it, or maybe there's some sinkholes, or maybe there's buried waste in the vacant lot next door that everybody knows that the builder used that as a dumping ground and dumped a bunch of crap and then covered it over, and that's why there's no house there. Any of that information that you know about the neighborhood, a cemetery, an old cemetery in the neighborhood that is, and we've had situations like that, that's within a mile radius of the house, that's not obviously a cemetery. It's so overgrown. It's not, the headstones are overgrown. You could walk practically right on top of it and never know that there was a cemetery there. And yet the neighbors know it. Everybody knows it. Those are the types of things that, if found out later, that you had knowledge of and failed to disclose, those would be a situation where you could be liable, in addition to the actual defects on the actual property. We had a situation through broker support. I'm not sure if you were on that call or not, Tom, but we had an agent who had a seller that did not disclose to her the fact that the land, the acreage, was prone to multiple incidents of sinkholes popping up in the land, which means there's groundwater there causing those sinkholes. And the agent was listing the property, and the neighbors told the agent about the sinkholes and it's the fact that it's prone to just pop up random sinkholes all the time. And so the agent's question to us on broker support was, what should I do? And I said, you have to disclose even if the seller won't, because the neighbors told you, and you can even say, the neighbors have told me this. I have no information, but you know, this, I've been informed of this. So then what you do is you put the burden on the buyer, go investigate, go get testing, go get a soil scientist, somebody, a geologist, whatever, to test before you buy this property to see how bad this groundwater situation is. Okay, because if you have multiple sinkholes popping up, they're popping up for a reason. Down here at the bottom, nothing in this subsection shall limit the obligation of seller, that's a separate legal obligation, or any applicable law to disclose to prospective buyers all adverse material facts actually known by seller pertaining to the physical condition of the property, nor shall it limit the obligation of prospective buyer to inspect and familiarize themselves with potentially adverse conditions related to the property and physical condition, any improvements, and the neighborhood in which the property is located. Buyers have a duty to inspect, but if there's something that is not obvious and is known, you can't put the burden on the buyer to have to dig that up. If you have knowledge, you've got to alert the buyer of the knowledge that you have, because we can't guarantee that the buyer uncovers and lifts up that one rock and looks under that one rock. We can't have that kind of, oh, it's their fault, they didn't lift the rug and see the hole in the floor. No, no. If you knew that hole was there, you got to disclose it, even if you're not asked. Any questions about this section? Lastly, and then we will take more questions. Lastly, I just want to mention this because anytime I talk about Beretta and anytime I talk about duties that we owe to clients, I always get the, oh, my fiduciary obligation, my fiduciary, my fiduciary. So I wanted to actually copy and paste language from Beretta. And this is, again, the Broker Relationship and Real Estate Transaction Act. It's enforced through litigation. And this is where the statute actually talks about the duties we do and do not owe to customers and clients. And it actually defines agency types, all types of agency. But it says a broker who performs brokerage services for a client or customer shall owe the client or customer only duties and obligations set forth in this chapter, meaning Chapter 10-6A of the Georgia statute, unless parties expressly agree otherwise in writing signed by the parties. A broker should not be deemed to have a fiduciary relationship with any party or fiduciary obligations to any party, but shall be responsible for exercising reasonable care in the discharge of its specified duties as provided in this chapter, and in the case of a client as specified in the brokerage agreement or brokerage engagement. And I assure you, none of our GAR brokerage engagements create a fiduciary relationship. This was written this way on purpose, and it was written by Seth Weissman, and that firm actually writes our contracts. They're not going to create a statute that's going to contradict our brokerage engagements. So we owe, we have to promote the seller's interest, but it is really in the seller's interest, if you think about it, to disclose known defects, because that's the best thing they can do to actually guarantee themselves or protect themselves from a successful lawsuit. Let me look in the chat real quick and see what kind of questions we might have had. Let's see. Lamar, you're asking, how do you keep an agent from sending you the whole report? You can ask, but if they send it, they send it. And if you're on the buyer side, I'm going to tell you, always send it. Always send the whole report if you're on the buyer side, because I want you to make the agent and the seller accountable for all the good, bad, and ugly, because that is the only leverage you're going to get. That is your absolute maximum leverage. And so I'm going to tell you to send it. Don't wait. Don't ask. Just send it. Send it even before you send the amendment, and deliver it to them. And when they tell you, oh, this and oh, that, remind them that it's deemed delivered to them and their client, and they're responsible for disclosing this regardless of whether they agree with it or not. But if you're on the buyer side, I would say send it first. And first and foremost, and send it every time, because you want that leverage. So your whole argument is going to be, hey, if me and my buyer go away, if you guys won't reduce the price, or if you guys won't work with us and we go away, guess what's not going to go away? All these 50 things that are on this report summary. And as is has nothing to do with it. And whether you open that report has nothing to do with it. And if you need some ammunition, just let us know. Of course, you guys have a copy of this report in the chat. I think Stephen put that in the chat, so you guys have a link to this presentation if you want. And you have all kinds of ammunition here that you can explain that if we go away because you guys won't work with us, guess what's not going away? Seller's obligation to disclose all this, your obligation to disclose all of it. And you either stick with us, the bird in the hand, and try and work it out, or somebody else is going to come in and they're going to get their own inspection. Plus you have to disclose all this, and it's going to get, it can only get more ugly.
Can I just tell you guys that I sold a house? I was the listing agent on a house on Rugby Avenue here in historic College Park. And we got an inspection report, and this house had been on the market almost a year. Okay. So we got an inspection report, and we really wanted to engage this buyer. And even though the seller thought, you know, they had renovated the house, they'd done all these things, but they had lived there for, I don't know, 40 years. Anyway, long story short, what did not go away was the $80,000 he had to give up in repairs. And the only reason he didn't have to do them is because it was a portfolio loan. And so the buyer really wanted to do the repairs himself. So it worked out beautifully, but he had to eat $80,000. And, you know, I had the same conversation with him. You know, you could say no, but it's not going to go away.
It's not going to go away.
Now you're going to have to fix these things. And
That's right.
So you're going to spend the money one way or the other. You might as well sell your house. And he took it really well. Honestly, I couldn't believe it.
Yeah, absolutely.
That's the highest dollar figure I've ever dealt with on an inspection report on a single family home.
And a question here, Carrington had a question. It says, isn't there a special step we can include that protects us from being responsible if the report is sent? No. First of all, special steps can be very dangerous, and I'm not a big fan of overuse of special steps, but legally you could write any kind of special step you want. But from a legal perspective, once these duties to disclosure are statutory obligations, so you can't protect yourself once you've received this information, because the statutes are there to protect the public. So I guess I'm not fully understanding what you mean by, is there a special step to protect us if the report is sent? Protect you from who? From the client that's going to be mad that you have to forward it? Or Carrington, can you kind of elaborate on exactly what kind of protection you were thinking?
Yes, because I remember doing a contracts class last year. There was something mentioned where we can put in our basically where we're able to write in somewhere where it says that we won't open anything that's sent.
Yeah, whoever taught you that, was teaching you something legally incorrect. Because that would never, ever hold up in court, and it would never hold up in a litigation. And that is why that was a bad and common practice that was going on. And it was believed by a lot of brokers and believed by a lot of agents that it was okay that if I didn't open it, you delivered it to me and I didn't open it, that somehow I'm off the hook. Just like there's this false belief that as is means I'm off the hook for disclosing. And you'll see where the GAR Forms Committee has added it in the brochure for sellers to educate sellers. As is has nothing to do with it. They've added it in the inspection paragraph. Well, now they've added language in the notice paragraph specifically to overcome that kind of misunderstanding, which is back here. Hold on a second. Let me see if I can go back.
Well, the contracts and paperwork in the GAR forms are constantly changing based on lawsuits that happen and also misunderstandings that are that brokers get a lot of calls on. So what may have been acceptable 2 years ago may not be acceptable today because it's probably been addressed in the forms. So that's why it's very important to have these broker chat calls, for you all to attend our classes, because everything it changes constantly.
Yes. And honestly, this was honestly, it was never okay. And it never, because I have been a expert witness for an attorney that was suing a broker for failure to disclose a defect. And I was hired as the expert witness, and I sat in the 9-hour deposition while this broker had their lunch eaten. I'm telling you, it was brutal. And things like this notice paragraph was extremely important because the broker, the agent for the broker did not deliver properly the information, which was on a survey that was provided by her client to her, and she did not deliver it, even though her client expressly told her to deliver to any prospective buyer. She did not properly deliver it to the prospective buyers. And so the buyers bought a house where they told her they wanted to build a pool. Turns out that the whole backyard was just loaded with all kinds of piping that was easement for the city. And there's no way in the world you could ever build a pool there. And the buyer expressed to her repeatedly that they wanted a pool, and she never delivered the survey that the seller gave her and said, make sure all prospective buyers get this. So, you know, but again, this bad practice of agents breaking rule number 1 and hearing somebody say, or you also have, Carrington, I hate to say it, but it's the truth. You have people that go out and teach classes, and they may be teaching things incorrectly based on their belief system and not based on the facts. And you have that. You have instructors do that. You have brokers do that. They teach what they think is correct based on what they hear other people saying or what their belief system is. But that's why I'm so obsessed with going and looking at what's in writing and making sure you guys know all the little elements of where it's in writing. And I'll say to you again and again, don't take my word for it. Here it is in writing. Here it is in the contract. Here it is in the law. Here it is here. And I want y'all to be armed with this information so that when you are up against an agent trying to get you to ignore what you should know, you have all the ammunition to come back and say, I don't think so. That's absolutely not accurate. Here's the real deal. Because when you are that well informed, you have leverage. You are the better negotiator. You're the stronger agent.
And I just say to you guys on the call that when I first started in real estate, our contract was like 3 pages long. Okay. And so now it's 8 or 9 pages long. And my only point in saying that is that because things change and lawsuits and situations and the market change, and our forms are constantly changing. So I just want to make sure you guys attend all of these sessions that we have. It's very, very important because I guarantee you your competition's probably not as engaged in the changes as you guys may be.
Agreed. And you know, so I'm gonna, I think, trying to post this link.
And I've got to sign off, Angie. I've got an appointment I've got to get on with. So
I've got to sign off too,
You've got
because
to
I'm
start
starting.
teaching. Yeah.
Thank you, guys. I'm starting the Contracts 101 in like 6 minutes. I'll be teaching from the training room here at the Camp Creek office, down here, the Atlanta Classic office in South Fulton. But you guys can join that Zoom presentation, and I'll have our Zoom host put in the link for that. That starts at 1 o'clock. Anybody can join, and we're going to be going over the loan exhibits and exhibits to our purchase and sale agreement that we've been working on, particularly a deep dive into the conventional loan exhibit and the temporary occupancy exhibit. It's an hour-long class. Anybody's welcome to join. And I'm going to have our wonderful administrative person put the link for that if anybody wants to link to that. That's going to be, we're going to get off this meeting and on to the next meeting.
I will be
Hey,
there
Angie, really quick. Angie,
Yes.
I will be there to teach session 4 of that same Contracts 101. So
Yep,
all
that's
right.
going to be next
everybody have
Monday.
a good afternoon. I got to skedaddle.
Okay, I heard somebody call my
Angie,
name.
are you guys going to be recording that contracts training?
It's not going to be on my computer. It's going to be on the computer here at the Camp Creek office. I'll ask them if they can record it because
That
I'm
would
not
be
going to be
great.
using my card.
I'm a dual career agent, and so I'm not always able to make these classes, but I would love it if you guys could record some of these meetings and send them out, and I can review them
Yes.
on my own time.
Yes, and we will teach it the first 4 Mondays of every month. We rotate it again. And we have a fake buyer and a fake seller, and we go through preparing to write a contract. Then we go through the purchase and sale agreement, and then we go through the exhibits to the purchase and sale agreement in our fake contract. And then lastly, we go through the amendment to address concerns and a deep dive into just amendments, terminations, things like that.
Okay, sounds great. Thank you so much. This is great.
Thank you. Appreciate it, guys. All right, on to the next.